We are also honored to have Judge Asakura Yoshihide, Vice President of Tokyo District Court, as the second keynote speaker. Judge Asakura will speak on the subject of the establishment of the business court in Japan. How can the judiciary assist for establishment of Japan as a preferred venue of dispute resolution? Judge Asakura, please, you have the floor.
Thank you, Ms. Komoto. Good morning, everyone. My esteemed colleagues from G7, ASEAN, and Japan, of course, and everywhere around the world. And hello to those participating online. I'm here today to tell you one thing and one thing only. That is that the Japanese courts, especially those in Tokyo, which handle many or most of cases related to international arbitration, are now changing dramatically. How? Let me explain it to you now. Could you change the screen to... Thank you. Now, to do that, first of all, I have to introduce you to the opening of the business court. Last October, Japan's first business court was established in Nakameguro, Tokyo, to concentrate on specialized business-related cases. Some of you may wonder where Nakameguro is. Well, it's there. It's a 15-minute train ride from here, or from Kasumigaseki, where the Minister of Justice and the main building of the Tokyo District Court are located. The business court houses the intellectual property divisions, the commercial division, and the bankruptcy and civil rehabilitation division of the Tokyo District Court, as well as the intellectual property high court. It has 5 stories above ground and 1 below, and although it looks rather small from the front, it is quite large from the side, with a floor area of 16,000 square meters. The business court is equipped with new facilities ahead of other courts. For example, all courts are connected to the web, and the grand chamber, which you can see, which is used to hear particularly important cases, is equipped with 2 large monitors. These courtrooms, which are used for cases to be heard by 3 judges, there are 7 of them at the court, and 8 round table courtrooms, which are for the frank exchange of opinions and discussion of solutions, are equipped also with a large monitor. In the business court, judges, my colleagues, and staffs actively pursue efficiency through digitalization, while further enhancing and strengthening their professionalism and international perspectives. We are committed to creating a new court that meets the expectations of our users. Specifically, in the business court, in addition to actively holding study sessions and exchanging opinions with outside experts, we utilize specialized human resources. And the court is the first in Japan to, And the court is the first in Japan to set up a web conference booth in the judges' chambers to enable flexible web conferences with attorneys, aiming to provide quicker and easier access to the court through the use of digital technology. Prior to other courts and divisions, last summer, the commercial division and intellectual property divisions of the court introduced an electronic filing system for court documents, allowing attorneys to submit documents and evidence to the court at any time and from any location online. The court also holds symposiums and other events with foreign judicial institutions, bringing together knowledge from around the world to exchange views on how to better resolve disputes. Well, camera back to me, please. And in the court, judges share their knowledge and experience to better understand the actual situation, including background circumstances of disputes, and to resolve them in a more appropriate manner. We also actively share the court's knowledge, resources, and advanced initiatives by providing them to courts throughout Japan. Oh, by the way, as I have been introduced, I'm currently the Vice President in charge of the entire civil division of the Tokyo District Court, which is rather large. And until this March, I was the Vice President specially in charge of this court. So I've been at the forefront of promoting these initiatives. Now, let's return to the subject of today's issue, arbitration. In April this year, as have been mentioned by Professor Kakiuchi, the Arbitration Act was revised, and there were two major changes in arbitration-related cases. First, it is now possible to file a petition to the district courts of Tokyo or Osaka, even if the case should originally be filed to a district court other than these courts. Many arbitration-related cases have been filed in Tokyo and Osaka even before the recent revision, but it is expected that the cases will now effectively be concentrated in Tokyo and Osaka. Second, the Japanese translation of the arbitration award and evidence are no longer required when the court deems it appropriate. This will streamline the time and cost for fighting arbitration-related cases. In response to this revised act, the Tokyo District Court, where many, perhaps most, arbitration-related cases are filed, has decided to handle all arbitration-related cases filed after April of this year in the business court, rather than waiting for the revised act, which is expected to come into effect by next April. Cases related to intellectual property will be handled by the intellectual property divisions, and all other cases will be handled by the commercial division. So how will arbitration-related cases handled by the business court change? There are two main points of change to be expected: speed and efficiency of the proceedings, and quality of judgment. Now, the first point. Until now, arbitration-related cases were handled in turn by more than 30 divisions at Tokyo District Court, each of which handled arbitration-related cases only once every few years. As a result, the hearings tended to be protracted, with the usual Japanese litigation process, i.e., a date for exchanging documents once a month, repeated over and over again until the parties had nothing more to say in rebuttal. Judges also tended to take an interventionist approach without giving much consideration to the realities and circumstances of international arbitration. They tended to take an approach similar to that of the appellate courts in Japanese litigation. For example, in an arbitration-related case in which the Tokyo High Court vacated the Tokyo District Court's decision in 2018, that is 5 years ago, it took the District Court more than 3 years to hear the case, while the arbitration itself took about 2 years. Now, this will definitely not going to happen in the business court. In the court, we are breaking away from the practice that was common until a few years ago, and we are hearing cases faster and more efficiently than ever before. Oh, by the way, I have to mention that cases other than arbitration-related cases in Japanese courts generally are also getting faster and more efficient these days through digitalization. But let me come back to the arbitration. Furthermore, as already mentioned, in arbitration-related cases, translations may be omitted, so it will make it faster and more efficient than before. And also, the time frame for hearings will be more predictable. Second, the quality of the decision. In arbitration-related cases, there are many cases in which claims are made for substantive re-examination of the arbitration award. As already mentioned, in the past, some judges have taken an interventionist approach, and the reason for this is that the dispersion of the cases led to the dispersion of knowledge, and it was difficult for judges to accumulate knowledge about international arbitration and the trends of related judicial decisions in other countries. This situation and mind-setting of judges affected not only the content of the decisions, but also the approach to the proceedings, and one of the main reasons for the length of the proceedings I have mentioned. While in the business court, judges are actively engaged in workshops and exchanges of views with outside experts, including foreign judges, arbitrators, and researchers to deepen their knowledge and understanding of international arbitration. For example, last week, we invited Judge Dominique Haché of the Supreme Judicial Court of France, ICA board member Ms. Yoshimi Ohara, who is a seasoned arbitrator, and Professor Kakiuchi, who just spoke before me, to an event at the business court, which was also connected to the Osaka District Court online. Well, incidentally, Justice Hayashi of the Supreme Court of Japan and President Watanabe of the Tokyo District Court also participated in the event, as did I, of course. In this way, the judges of the court have been accumulating expertise in international arbitration and trends in judicial decisions in other countries. And the concentration of cases in the court makes it possible to hear arbitration-related cases speedily, efficiently, and to make appropriate decisions, and improving the predictability of conclusions. But we must not forget that not all cases will be obliged to be filed in the Tokyo District Court. So, we would actively share the know-how accumulated in the business court by providing to the court throughout the country, including Osaka. And we will also receive inquiries and engage in dialogue with these courts. This, I believe, will result in faster and higher quality of trials outside of Tokyo. Well, the recent revision of the Act, the establishment of the Business Court, and the consolidation of arbitration-related cases within the Tokyo District Court have brought about and bringing dramatic changes in the court's approach to international arbitration. Let me reiterate. Courts in Japan, especially in Tokyo, are now changing substantially in an arbitration-friendly direction. I believe that the court will do much to support Japan's attractiveness as an international dispute resolution forum. Thank you very much for your kind attention. Thank you.
I thank Judge Asakura for his speech.